All rise. For the 5th District, State of Florida, is now in session. Honorable Chaplain, all presented business before drawn near your attention, you shall be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning, everyone, and welcome to a session of oral argument in the 5th District Court of Appeal. As you've already heard, I'm Judge Griffin. To my right is Judge Torpy, and to my left is Judge Cohen. We're down to 2 cases this morning on the docket, and so we will start this morning with the capital cargo case, and then we will do the MH New Investments case, and the other 3 are permanently or temporarily gone. Counsel for capital cargo can come up when you're ready. As you're coming up, I'll remind you that each side has 20 minutes to argue. There's a clock on the podium that you can use to keep your time. If you'd like someone to help you keep an eye on rebuttal time, just let me know, and I'll do my best. And counsel can begin when you're ready.
I don't know if opposing counsel is your opposing counsel here? Sorry. Okay, all right.
May it please the Court, my name is Stephanie Cook, and I represent the appellant in this case, Capital Cargo International Airlines, Inc., and I'd like to reserve 5 minutes for rebuttal, please. The central question in this case is whether Mr. Guadalupe was an employee or an independent contractor when he did work for CCIA. It is a very fact-specific analysis, so I'd like to begin and set out the facts in this case and then look at the 9 factors set out by the Supreme Court in Cantor versus Cochran.
Let me ask you this as just a threshold question. What are you asking us to do? What relief are you seeking here?
Your Honor, we're asking that you reverse the Commission's affirming of the deputy's findings that A&P mechanics, specifically Mr. Guadalupe.
Do you want us to reverse and direct a judgment in your client's favor, or do you want us to reverse and remand it back to the hearing officer to re-weigh the factors and come up with a new ruling?
Your Honor, we would preferably to reverse the lower court, but alternatively to send it back down and to reanalyze the factors. When you look at the findings of fact...
how can we just re-weigh the factors ourselves and enter judgment for you?
Well, Your Honor, I believe that the findings of fact that the deputy did make, we don't have issue with that. We feel some were omitted, but we do feel that the findings of fact that were made clearly do not support the conclusions of law that he was an employee in this situation, that even if you don't...
Was there any factor that militated in favor of him being an employee, that weighed in favor of him being an employee?
The only 2 factors that we would concede arguably would weigh in that favor is that it was a business. If you look at that in Messer, this court looked at that and said that's a rarely insignificant factor, and whether the principal is or is not in business. And in looking at the cases decided by this court as well, that those seem to be the 2 most insignificant factors. The most significant factor...
What was you said which... enumerate for me the factors that you say militate in favor of him being an employee.
The only 2, Your Honor, that I would concede would militate that way would be whether or not the work is part of the regular business of the employer, which is number 8, and number 10, whether the principal is or is not in business.
Okay, what about the length of time for which the person is employed?
Yes, Your Honor. In this case, although he worked for them for the period of 2006 to 2009, it was extremely sporadic. He was on a list...
I'm trying to understand that extremely sporadic, because if I... and I can tell you that there's a reason I went to law school. It's because I couldn't deal with math as soon as they started using letters.
but in looking at the 2008 income, it looks like he made $19,637.50 in 2008. And if my math is right, that's 785 hours over the course of a year, or 65 hours per month. Is that right?
Yes, Your Honor.
And then if we go up to June of 09, and this is a little bit more approximate because I don't know how far into June it went. It might have gone a couple of weeks into June. He earned $10,725, and if my math is right on that, that's 429 hours, or 85 hours a month. It seems to me that that's a fairly substantial amount of time. And
Your Honor,
there's nothing insignificant or sporadic, as you have termed it, about those numbers of hours.
Certainly, Your Honor, his amount of hours worked did increase beginning in 06, only $100, up to $19 in 2009. However, if you look at the cases, it is not just length of time of employment. There are cases such as Kearns, where the person worked for a year and a half at the same place every day. They were found to be an employee. In this case, he's on a list, and he's only called on an as-needed basis. Sometimes we're more needed than others. But it wasn't a routine employment situation where he was coming...
But these hours and that amount of income seems to be fairly routine in my view.
Your Honor, the testimony was that, again, he wasn't there on a routine basis. It was on an as-needed basis. Certainly some years was more needed than others.
The administrative hearing officer below had these numbers in front of him, and could that judge not have viewed it differently?
Your Honor, the numbers that you're referring to were in the 6061 application that was filled out by the appellant in this case. At the end of the hearing officer kept out both 6061 forms, the one the worker filled out, which is the only evidence submitted by appellee, and the 6061 was also kept out that the appellant offered as well. So although those numbers were in front of him, at the end of that hearing, for hearsay reasons, both those forms were kept out of the record.
I wanted to ask you about some other factors, because you said there was only two. So that was the third one, and I guess you take issue with whether that militates in favor of being an employee. Then we got one, the method of payment, whether by time or by the job. This fellow was paid by the hour, wasn't he?
Yes, Your Honor, he was paid by the hour.
Doesn't that militate in favor of him being deemed an employee?
Your Honor, on that point, if you look at many of the cases analyzing that same factor, our position is that would be similar to submitting an invoice for time worked. That's the way that they kept track of the time, and he was paid differently than the employees. The employees were paid.
The whole idea here is that the real crux of the inquiry is whether there's a control over the person. And if they're being paid by the job, the employer is indifferent about the amount of time that they put in, so there's not any control. But if they're being paid by the hour, then production becomes something that the employer is concerned with. And so this fellow was being paid by the hour, and isn't it appropriate for the lower court to have weighed that factor in favor of employment?
Your Honor, although we understand the control issue, in this case it was because of the airline business and the log sheets and all of the time sheets that have to be filled out for the FAA, it was more appropriate for them to do this on an hourly basis. He was paid differently from the employees who were salaried. They did his on an hourly basis because it was as needed, and it was simpler. He got paid on a weekly basis, where the employees were paid semi-weekly. They were salaried, and for the airline, our position would be that that factor doesn't weigh, because in this case they're looking at the FAA regulations and they're filling out these timesheets and these log sheets, and it was just an easier way to keep his time.
What about whether or not the work is a part of the regular business of the employer? Wasn't this employer in the business of fixing airplanes, and didn't this employer have a bunch of employees that were working as mechanics?
Your Honor, yes, at the beginning when you asked me the two, I would agree that that is one of them, but I'd also like to point out some other cases where, although they had employees doing a job similar to that of the independent...
What did you just concede, counsel, that factor also militates in favor of...
The only two, Your Honor, that I would concede would be that it's the regular business of the employer and the employer's in business. And those two factors this court looked at in Messer versus Department of Labor Employment and said both of these are fairly insignificant factors. Again, the most important factor being the right of control. If you look at the cases...
Wasn't there evidence from which the hearing officer could conclude that this employer did exercise the right of control and that they supervised the work that was being done?
Your Honor, the only thing that was supervised was the required inspection items that the FAA says has to be inspected.
Why should that make a difference?
It makes a difference because they weren't supervising the details of his work, but rather the end result. And it makes a difference because a government regulation that certain items need to be inspected doesn't amount to the...
Wasn't there testimony that as the work was being performed, a supervisor would observe it?
There was testimony by Mr. Mueller, and he said two different things that I think are important on this point. He did say that when people are working, he's moving around and he's looking at what is going on, not looking at so much the details, but making sure the job's getting done, which again, cases that I'll review with the court in a moment, it's okay to supervise the work to a certain degree to make sure you're getting an end result. But in this case, he said that if it's not a required inspection item, at page 35 of his testimony, he said, then it's his word it's done properly. He doesn't inspect it. The other gentleman that testified that was a former independent contractor A&P mechanic but became an employee in 2007 said that when he worked, there was no full-time employee supervising him at all, that he was doing his work on his own. So, again, we're looking at were the details of the work, was that supervised, or the end result? And in this case, what was supervised were those required inspection items that, again, the FAA required be inspected for safety purposes.
Didn't the employer provide a place of work and the tools, at least the major tools, the large tools, the diagnostic tools with which to do the work?
Your Honor, the company did provide some of the major machinery, but he brought all of his own tools.
He brought hand tools with him, right?
Right.
They provided all of the expensive tools, the big diagnostic computers and things like that. I mean, can't the trier of fact weigh that factor in favor of employment?
Your Honor, again, there's hardly any cases that you would see where they bring all of their own tools. Most of the cases when you have large machinery, they're not going to carry that around with them as a practicality. But and the testimony was that he always brought his own hand tools, and then again, the big machinery was there.
Well, I mean, there's a difference between a company dropping a vehicle off at a mechanic's shop and saying, fix the vehicle, and then paying a flat price for that at the end, and a company who has in-house mechanics, who has them at their workplace, fixing things at their workplace, watching what they're doing, providing some tools, providing some oversight. There's a difference between those two, right? I mean, clearly in the former, we're talking about an independent contractor situation, but in the latter, isn't it more appropriate to treat it as an employment situation?
No, and I think when you look at the specialized nature of the occupation and that the mechanics always carried their own tools with them rather than coming to a workplace where all of the tools are provided for them. If you look at T&T Communication versus State of Florida, there it was cable installers. And in that case, you had both the worker coming to work would bring his own tools, but there was also some tools provided by the company. If you look at D.O. Cressman versus State of Florida, those were cable splicers in same situation. They had their own tools that they would bring with them, but they also used some of the company's tools as well. So just because some of the tools were provided by the company certainly wouldn't deem a finding of an employee, because I think in this situation he had to have a license from the FAA. It's a very specialized skill, a very specialized training, and he carried his own tools. So I think if he had come to the job site and all of them were provided, that would have been different. Again, the biggest factor we're looking at is control. When looking at control, This court decided in Hildreth, looking at different kinds of truck drivers in that case, this court found an independent contractor relationship when the agreement could be terminated at any time, no insurance, no taxes were withheld, no benefits.
It seems to me, though, that what you're arguing is, well, yes, the employer had control, but the reason for the control was because the FAA mandated it. And it seems, though, that there's a concession, or should be a concession, that the employer exercised control. And then you debate the reason for that.
Your Honor, our position on that would be that there wasn't an exercise of control, but rather a inspection of the end result, which numerous cases have said that control over the details of the work is the type of control that would justify finding an employee-employer relationship.
When it comes to work, they give them assigned tasks. This is what we need done. This is how we want it done. They provide a manual. He's got to review the manual. And so it seems that they're giving them, that they're telling them when to show, where to show, how to do it, what to do and how to do it.
Your Honor, they're told when to show to the extent that if they want to show up, they can. They're called from a list in the morning. They do get a list of tasks for that day, and they do get a manual. But for instance, in 4139, Management versus Department of Labor, a case decided by this court, it was a similar situation. The housekeepers would show up that day to clean the condos. They would get a list of things to do. They would get a job description similar to a manual, and they would go and they would do the house cleaning. At the end result would be inspected, and this court found an independent contractor relationship. It was similar to that. They certainly gave him a list of things to do, and certainly they inspected the items at the end, the items that were required to be inspected. So that, in and of itself, wouldn't be the degree of control in the details of the work. When he's there on the site doing the job, no one was supervising him in those details. Rather, they were looking at the end result, which would deem a finding of an independent contractor relationship rather than that of an employer-employee relationship. The other factors that weigh in favor of finding an independent contractor relationship is...
So you're down to 5.
Okay, thank you. I'd like to save the rest of my time for rebuttal. Thank you very much.
May it please the Court. My name is Peter Penrod, and I represent the appellee in this matter. On appeal, Capital Cargo has raised 3 objections to the Department's final order, finding that its contract A&P mechanics, as well as the joint party, are employees and not independent contractors. First, it has argued the final order is unsupported by the competent substantial evidence in the record. Next, it argues the Department erred in omitting undisputed record evidence that supports findings the joint party and other individuals are its independent contractors. And finally, it argues the Department made incorrect conclusions of law. In reviewing this final order, the standard of review for findings of facts is whether these findings were based on the competent substantial evidence in the record, and any conclusions of law made by the Department must be accorded great deference and upheld unless clearly erroneous. Before moving to a discussion of this issue, I ask that the Court consider the following facts. Capital Cargo has 2 classes of individuals performing services for it as A&P mechanics. One class it considers employees. The other class at issue today it considers independent contractors. Both classes perform the same type of services for Capital Cargo and are supervised in substantially the same manner. The only difference between these 2 classes is that one class is a set of full-time employees that are paid a salary as well as benefits, and the other class, the class at issue today, are only provided an hourly wage.
Mr. Guadalupe didn't appear at the hearing. Would you agree that the documentation that he filled out, the 6061, is inadmissible hearsay?
Yes, I would agree. And if my recollections of the facts are correct, it was objected to at the hearing for that coming into evidence by Capital Cargo's representative.
So what admissible evidence did the hearing officer rely upon to make the findings?
It was based upon the testimony provided by the Capital Cargo's witnesses and representative.
Specifically?
It looks like, well, depending on what factors we're discussing, with the first factor of control, It was a testimony about the type of work, how they supervised these individuals, what type of tasks they performed, how they were paid, and their ability to terminate these individuals at any point during an assignment without incurring any penalty. Each of these factors indicates a degree of control by Capital Cargo over these individuals that is inconsistent with the notion of an independent contractor relationship. Section 443-1216 sets out the law regarding independent contractor relationships under unemployment compensation law, and it states that the normal common law rules applicable in determining employee-employee relationships apply, and the Florida Supreme Court, as was articulated by opposing counsel, has set out the test, and that test is based on the Restatement Second of Agency Torts of Servants from 1958. And the first factor of this analysis is the most important factor, and that is the extent of control the master may exercise over the details of the work. The hearing officer in this case made the following findings of fact relevant to this issue, and that is Capital Cargo retained the ability to direct which tasks will be performed by each.
What authority does the Court of Appeal have in reviewing this, as counsel labeled it a fact-intensive case? What authority do we have to...
You have the authority to determine whether the findings of fact are based on competent substantial evidence, and then whether or not those facts support the ultimate conclusions of law. If the facts are unsupported, or if the facts are unsupported and additional findings are necessary, then it would have to be sent back to the lower tribunal for an additional factual hearing. If this court disagrees with the conclusions of law, then it can simply reverse the conclusions and alter the outcome. If the hearing officer found that Capital Cargo directs what tasks will be done by each mechanic, supervises each mechanic to ensure they're performing their assigned task, may require any mechanic to submit to a drug test, and provides the same supervision over the mechanics it considers employees as those it considers independent contractors, and finally, it strictly prohibits any mechanic from subcontracting his or her assignments. Florida case law holds that in determining the degree of control an employer exercises, the decisive question to ask is who directs what shall be done and how and when it shall be done, and whether the individual performing the services is free from control with regards to the details of the engagement. And as the evidence has proven in this case, these individuals were not provided much freedom with regards to how they perform their task. Moreover, the record indicates that Capital Cargo retained the unilateral authority.
Isn't that really part and parcel of FAA requirements? They're very strict in terms of documentation of work that's done upon airplanes, and isn't that part and parcel of this industry in general?
I have two responses to that question. The first is the authors of the restatements noted that the fact that a state regulates the conduct of certain professions through the operation of statutes, that doesn't in and of itself prevent an employment relationship from being created if the employer still exercises a degree of control over the employee. For example, the Florida Bar regulates attorneys, so that'd be like a law firm arguing that it doesn't retain enough control, or the only control it exercises over its employees is that required by the Florida Bar.
Yeah, but the Florida Bar doesn't require that you document everything that you've done during the course of a case. The FAA requires that when you're working on an airplane, that you document all service that you're performing upon an airplane.
Right, and if these individuals were true independent contractors, they would be independent employing units. So any FAA regulations that would have applied to Capital Cargo would equally apply to these independent contractors. And to me, it seems like the liability would then shift from Capital Cargo to this individual employing unit that it's subcontracted its work out to. And I feel like the fact that Capital Cargo is retaining all the liability in this case, these individuals are its employees, not independent contractors. The Florida Supreme Court has held that the unilateral authority to terminate employment without incurring penalty is indicative of an employer-employee relationship. The first DCA in Lindsay v. Willis noted that the unrestricted power to terminate services at will is strong evidence which demonstrates that the person employed is not an independent contractor. And this is based upon the theory that such power is inconsistent with the notion of an independent contractor, under which the contractor has the legal right to complete the project contracted for and to treat any attempt of completion as a breach. And in this case, the individuals had no ability to challenge Capital Cargo's authority to terminate them in the middle of any assignment. Thus, the record illustrates a degree of control by Capital Cargo over the joint party and other A&P contract mechanics that it considers that is inconsistent with an independent contractor relationship. The third factor of the Cantor analysis is also an important factor, and that is the kind of occupation with reference to whether in the locality the work is usually done under the direction of an employer or by a specialist without supervision. Capital Cargo has argued that A&P mechanics are highly specialized and the only supervision they provide is that required by the FAA. The facts in this appeal indicate Capital Cargo supervises all the work of the A&P contract mechanics but made no findings with regards to the type of specialization that is required by these individuals. Thus, the record supports a finding that A&P mechanics usually perform under the direction of an employer, and this indicates the existence of an employer-employee relationship. And this court should reject any of Capital Cargo's arguments that rely on facts not made by the lower tribunal. The next factor that was brought up is the length of time that the individual is employed, and this is the sixth factor of the Cantor analysis. Capital Cargo has argued that the joint party only works sporadically over a period of two or so years. The special deputy found the joint party worked for a period of 2 to 3 years, but made no findings regarding how frequent this individual performed services during this time period. This court again should reject any attempt for Capital Cargo to rely on facts not made by the lower tribunal. In comment J of the restatement, the authors noted that the shorter the length of time an individual performs services for an employer, the less likely he is an employee. And as the facts in this case make clear, these individuals perform services covering a time period of 2 to 3 years, which is sufficient to create an employer-employee relationship. Seventh factor of this analysis, of the Cantor analysis, is the method of pay, and that is whether it was by the time or by the job. And again, the facts in this case show that these individuals were paid by the hour, which tends to show the existence of an employer-employee relationship. The eighth factor of the Cantor analysis is whether or not the work is part of the regular business. Capital Cargo has conceded this fact but tried to minimize its importance. And the importance of this factor cannot be understated. In Cantor v. Cochran, the seminal case on this subject, the court stressed the importance of this factor by noting one of the decisive factors in determining that a relationship was not that of an independent contractor is that the services to be performed are outside the normal course of the employer's business. And the facts in this case again show that these individuals performed services that was Capital Cargo's main business, repairing airplanes. The ninth factor of the Cantor analysis is whether or not the parties believe they are creating the relationship of master and servant. The special deputy made no findings with regards to the parties' belief of their relationship. So any argument on this issue by Capital Cargo should be rejected since there are no findings.
Was it the undisputed evidence that Mr. Guadalupe had, or that there was an acknowledgement that they were independent contractors when they signed off on certain documentation?
Yes, I believe there was record evidence that indicated they had to sign a document stating that by accepting payment, I agree that I'm an independent contractor, or something to that.
Was that disputed in any fashion?
It does not appear to have been disputed at the hearing of Mr. Guadalupe.
And yet the hearing officer ignored that evidence.
Yes, I believe that. Actually, even if we just assumed the lower tribunal had made these findings that these individuals did sign these timesheets agreeing they were independent contractors, the Florida Supreme Court has consistently held that it's not the parties' statements as to their relationship that is the deciding factor, but the manner in which they conduct themselves. And as the facts in this case have shown, these individuals in Capital Cargo embrace an employer-employee type relationship and not an independent contractor relationship. The next argument raised by Capital Cargo is the department erred by excluding or omitting undisputed factual evidence that would support findings that the joint party and other contract A&P mechanics are independent contractors. And Capital Cargo had put forth 16 suggested findings in their initial brief, and each of them related to one of the following factual scenarios. The first one is that the FAA licenses A&P mechanics and requires Capital Cargo to provide supervision over these individuals. The next pattern is the joint party worked full-time with another airline carrier during the time period in question. The third argument they put forth is the joint parties signed a timesheet indicating he was an independent contractor. And the last scenario put forth was Capital Cargo required the joint party to complete an IRS form 1099. The problem with this argument is that it's asking this court to make findings of fact, which it can't do. However, even if the lower tribunal had made each of the proposed findings by Capital Cargo, it wouldn't alter the outcome of this appeal. The authors of the restatement noted in comment I, the fact that the state regulates conduct of an employee through the operation of statutes requiring licenses or specific acts to be done or not to be done does not prevent the employer from having such control over the individual as to create an employment relationship. Thus, the fact that the FAA regulates Capital Cargo and requires a certain amount of supervision over its employees does not alter the outcome of this appeal. Moreover, the joint party's employment with other entities has no bearing on its relationship with Capital Cargo. And finally, as previously argued, the party's belief as to the relationship is not the deciding factor, or excuse me, the party's statements as to the relationship is not the deciding factor of whether they are in an employment relationship, but rather how they carry themselves in their everyday engagements. And in this case, it's clear the parties embrace an employer-employee relationship. Therefore, even if the lower tribunal had made all of Capital Cargo's proposed findings, the court would still be compelled to affirm the final order. And the final argument raised by Capital Cargo is that the department's conclusions of law, number 9 and number 11, are not supported by the facts in this case. In conclusion of law number 9, the special deputy determined that the joint party performed services for Capital Cargo over a period of time sufficient to establish an employer-employee relationship. This conclusion of law is supported by finding of fact number 2, which established the joint party performed services for Capital Cargo from 2006 through June of 2009, and this period of time is sufficient to create an employment relationship. In conclusion of law number 11, the special deputy found that Capital Cargo exerted sufficient control over the joint party to create an employer-employee relationship. This conclusion is supported by finding facts number 6 and number 11, which established that Capital Cargo supervised the joint party in the same manner it supervised the mechanics it considered employees, and had the unilateral authority to terminate this individual's services without incurring breach of contract penalties. Because these conclusions of law are supported by the findings of fact and are a reasonable application of the applicable legal authority, Capital Cargo has failed to demonstrate that the department erroneously reached these conclusions. In closing, I ask that this court affirm the department's final order and hold that the joint party and other individuals performing services for Capital Cargo are its employees and not independent contractors. Thank you for your time.
Thank you.
Thank you, Counsel.
Your Honor, in this case, the findings of fact below are not based on competent substantial evidence. If we look at the evidence in the record, the Department of Revenue testified that what they relied upon in reaching their determination was his application. He didn't bother to show up for the hearing twice. His application was thrown out. We're left with 2 A&P mechanics that used to be what they considered themselves to be independent contractors. Mr. Guadalupe was working full-time for another airline. He was on a call list. The 2 gentlemen that testified said that everybody in the business understood that you could supplement your income by getting on one of these lists, and they all viewed themselves as independent contractors. They didn't get benefits, no taxes were withheld.
Where in the record do we know that he was working full-time for another company? We know he was employed by another company.
Well, Your Honor, we draw that from the testimony of Mr. Mueller, who said it was his understanding that he worked full-time for All-Star Air Cargo, and the Department of Revenue testified the reason that this all got started is they had so many wage credits attributable to that airline and then not for CCIA. So that's what deemed the inquiry. From those things, I would support finding that he worked at least a lot more for that airline, if not full-time. He wasn't receiving, again, benefits, insurance. He brought his own tools to the job site. The amount of control, the testimony that we do have, they said basically if it's not a required inspection item, it was on your word that you were completing it. And this goes back to the level of skill that was required, which is another one of the Cantor factors. Because there was so much skill required and licensing required, these guys basically knew what they were doing. They didn't require a lot of supervision other than, again, those required inspection items. There's no, again, the only evidence offered was the application that was then thrown out. We're then left with the CCI employees, 2 of which testified that, look, yeah, I worked for another airline as well, and I used to come to CCIA and got on their call list. I signed the statement that said I was an independent contractor. Everybody in the business understood this was an independent contract relationship to supplement the income. And if you look at particularly cases decided by this court, again, Florida...
How was he supervised differently than the employee mechanics?
The two employees that testified said that although the supervision wasn't that different, again, if you go back to the skill level, we look at the two cases where you're talking about the cable splicers, you're talking about the cable installers. When you have a high level of skill, the supervision may not necessarily be all that different. But both of them testified that at least one gentleman, when he was working as an independent contractor, he said there was nobody even on site at that point in time when he was working in that independent contractor status. But I will state that it wasn't a huge difference in the supervision, but again, that's because we're talking about extremely skilled workers who don't require a whole lot of supervision. Again, Mr. Mueller testified that he's walking around, he's now gotten promoted and he's in a supervisory position, but he walks around, he's not checking the details of the work, he's looking at the end result. And this court has said many times that, just looking at the end result to make sure that it's done satisfactorily does not just transform the relationship into one of employer-employee. We're looking at whether those details of the work are being supervised. Again, in Florida Enterprises versus Unemployment Compensation Appeals Commission, you've got timeshare salespersons, and this was the same kind of situation. They could work when they wanted, come and go as they pleased. They had to be present for their shift. They got no benefits, insurance, taxes not deducted. They worked without.
What do you think is your most helpful precedent? If you had to pick out one precedent that you think is most helpful and compels reversal here, which one would you want me to look at?
There's a couple really good ones. I would probably go with 4139 management.
Well, give me just one precedent.
Okay. 4139 Management Inc. versus Department of Labor, which is 763 Southern 2D 514, which is a decision by this court. I would take a look at that one, and the reason would be, again, these housekeepers are only used on an as-needed basis. They come in, they do get a list of things that need to be done that day. They go and do it. It's then inspected at the end of the day. They get a job description, which I would say is similar to a manual that tells them, how they want the job to be done to a certain point, but they're not directly supervised. They can say no, they can say yes, they can come and they can go as they please, and those facts are very similar. They didn't get, given 1099 forms.
That was a housekeeper case, is that what you said?
Yes, it was a condo association that would have
Were they paid by the hour or were they paid by the job?
I believe they submitted invoices for the time that they had worked, and then they would be paid by those invoices. It's unclear whether those invoices were detailed time or whether it was by day. It just says that invoices were submitted and then they were paid based on those invoices.
We don't know whether they were paid by the hour or paid by the job.
It just said, no, Your Honor, it just says that they submitted invoices for payment, so I don't know exactly what was on those invoices. Again, no taxes were withheld, no sick pay, no vacation. They could decline the request and then they would just ask somebody else. Again, in this case, Mr. Mueller testified that he would go down the list. If somebody said no, no big deal, go to the next one and the next one and the next one. And that was similar to that situation in 4139. I did want to point out another case really quickly here is 84 Lumber versus Bethel, which was a garage door installation case. In that case, the doors were supplied by the company. The worker was working for other companies installing doors as well at the same time, and no benefits, no sick pay, 1099 form, a similar situation. So we would ask this court to find that the findings of fact were not based on competent substantial evidence in the record and reverse the Appeals Commission. Thank you.
In the garage door case, no one came out and inspected and supervised, did they?
They didn't supervise during the work, Your Honor, but they would come. They certainly would come at the end to see the end result. Thank you.
Thank you.
Thank you, Counselor. Well done.